Hi, everybody. This is Guy Regev with another episode of the Tech Twins podcast. Today, we're going to be talking about both patent law and life with Steven Saunders, our patent attorney. Um, Steven Saunders is a patent attorney over at Nutter patent law firm in Boston. And I'm going to let him introduce himself.
Hi, thanks. Again, I'm an electrical engineer when I started life, and for some reason I took a left turn into law school. And that was 27 years ago, and I've been a practicing patent attorney ever since. As Guy mentioned, I work with a firm in Boston. It's actually a general practice firm. I'm the co-chair of the intellectual property department in the firm. It's called Nutter, McLennan, and Fish, but we call it shorthand Nutter. I also get involved in a lot of startups. I've been an angel investor for a dozen or more years, invested in a healthy number of companies around the Boston area, primarily in New England, and although not necessarily upfront, usually through the angel groups I participate in. And I handle anything that touches patents is something I work with, whether it's me directly or one of my colleagues who handles something. For example, if it's a life sciences thing, I don't do it. I give it to my life sciences partner. But generally technology, medical devices, software, hardware, etc., is some things I've been working with over the years. Glad to be here and happy to answer your questions.
Happy to have you here, Steven. Happy to have you here. Do you have a question to ask him here?
Yeah. So the first thing I'm curious about is why should a company, and I mean specifically very small startup companies, invest and choose to patent their technology? What's the main reasons for patenting? Also, I would like to know what's the various decision factors in whether to choose a patent or a trade secret. What's the best, and what are the reasons behind it?
Okay, let's start with the first question. What are the reasons that a startup would want to have invest in patents? So first of all, it's always a factual situation where your patent lawyer needs to work with you to determine your business goals, and you need to talk about not only your business goals, your markets, if you want to be acquired, if you don't want to be acquired, if you're raising money. There are a lot of variables that go into whether you want to patent something. And of course, don't forget the technology is important also in this situation. So a patent is something that is expensive. And so as a startup company, as any company, frankly, and when I say expensive, I don't mean just dollars and cents. I mean, you're going to spend time on it, it's whatnot. It's going to collectively, it's a expensive asset. But like any asset you spend in business, you want to get a good return on your investment. You don't want to spend more on your patent than you're going to get back from it. What you get back from it, though, is intangible sometimes. What a patent buys you is the right to stop others from making, using, or selling the technology. So it effectively gives you exclusivity in the technology. But at the end, though, it only gives you the offensive right to stop somebody from making, using, or selling it. So to come back to the core of your question, why does anybody want to get a patent on this? It really, you got to ask if your business could benefit from a patent. What would an investor think about? And what does an investor normally care about? They care about getting a good return on their investment. So they're going upstream to the potential acquirer of the technology. So again, you kind of want to build like a war chest or something, a fence surrounding your business or that you're trying to protect. Mm-hmm. And so a company that comes in and acquires you knows that when they're acquiring you, that they're going to have a healthy protection for their investment. They spend $100 million to buy you. They want to know that their investment is protected, and it's not. So you're not spending all this they're not spending all this money, and somebody just knocks you off real quickly.
Right.
So that's really the Cliff Notes, the short version answer. The last sentence or two, not the whole wind-up that I gave you there. Of course, there are other reasons you want to protect something. Some people just want to protect for, they want to protect something for marketing purposes, and sometimes patent pending has some benefit. Also, if you're in a very litigious market or very competitive market, like the medical device space, for example, where you get a good product, there are high margins, a lot of investment goes into it, you almost definitely need to get a patent in that space to protect, because again, Baxter or Abbott or any of those companies, they're going to come in and buy it. They want to know that your technology that you've spent a lot of money innovating on is protected. And don't forget, you're spending a lot of money to develop this. You don't want to just hand the solution to someone else to just run off.
Yeah.
Really
By the way,
fun.
you mentioned a term called patent pending. What exactly is that?
When you file a patent, and if you know what a provisional patent is, application, that's also patent pending status too. Provisional patent application is something that's earlier in the stage, but it just means that you have a patent that may or may not issue someday, and that's it. However, it does give notice, warning to anybody who's looking at your technology and knows patent pending that, gee, maybe I shouldn't spend $5 million developing a business around this technology that you guys say there's patent pending. So it has some modest value.
Yeah. Okay.
A lot of times and there's marketing value to it in consumer spaces.
Yeah.
Particularly, you've seen the commercials.
Yeah. But
then
you said that the patent basically protects you or prohibits from other companies to copy your technology. But is that really true? Or other companies can actually use the technology that is described in your patents and just pay you royalties?
You can sue somebody for infringing your patent and stop them from making, using, or selling it. Now, you raise a really good point. This might be a little too fine-tuned for the audience here, but in the old days, in the U.S., I'm just talking U.S. now, you prove patent infringement, and you can just get an injunction which stops the other party from making, using, or selling, and you're done. That's not the case anymore. If you can get reasonably compensated with lost profits or some monetary thing, you may not be able to get that injunction. And therefore, of course, getting into a lawsuit, if you willfully infringe somebody's patent, that they'll give you punitive damages, they'll punish you. So in addition to the royalty, they might charge you millions of dollars of punitive damages.
Right.
And you also might get enjoined or prevented from doing it anyways. But that's a little up in the air. Now, a lot of other countries don't have that system. Many other countries, you get enjoined right away. And so one of the things almost every client I have, I'm not kidding, even startups, all want to go worldwide in their patent protection. When I say worldwide, I don't mean they file in 50 countries, but they all file outside of the U.S., and so, because, patents are regional. A U.S. patent can't stop somebody from doing something in other countries. So you have to think of global protection also. Which, we'll start getting very complicated when that happens, and expensive. Like if you're spending X dollars in the U.S., when you go national into Europe and China and Japan, it just goes to 3, 4, 5x in expense. So you have to think very carefully about where to go, where to protect it.
Got it.
Yeah.
And what exactly is a trade secret? When and how should I use it if I want to?
Well, one thing I like to tell people, you don't want to patent something if you can never tell if somebody's infringing it. So let me give you an example. Of course, let's take a manufacturing process where you take rubber, you heat it up to 350 degrees, you wait 2 hours, you pop it out of the mold, whatever. All you're going to see at the end of the factory is the finished part. You're not going to know the time, the temperature, etc.
Yeah.
And so that's just one example of something. You keep the process as a trade secret inside the company. And so that goes on forever, as long as you keep it secret. If a secret leaks out, it's dead, it's gone. But if you keep it secret, and think about it, sometimes that's a better strategy, because like take Coca-Cola. I don't know if they're actually that's been released as a public. Some of my students, when I tell them, I use that as an example, they say, "Oh yeah, that's out there now. People know it." But I think just let's sake for discussion, say it isn't. That's been going for 100 years, and that created a really nice business for them. Yeah. So how do you enforce that? Well, first of all, it can't be kept as a trade secret if it's not a secret. So if I decide to create some glasses and they have a special coating on it that makes it bulletproof, when I start selling these, if I say I want to keep this invention as a secret, if somebody can reverse engineer it, my trade secret's done. Yeah. So that's when you need to patent it in that case. However, assuming again it's commercially valuable, again it all matters about making a return on investment, the ROI. So if so you want to think about the whether it's detectable, I call it detectability. And there's a lot of gray in there too. For example, a chemical process may use a certain solvent, and that solvent may leave a residue that's detectable under a microscope, and so then you can detect it. Or maybe there's only really one way to do something, and you were the one who discovered it. Yeah. Maybe you patent that. Maybe there's something you're at a university, and you have to publish. Like a lot of universities, you have to publish. You might patent it then. Yeah. Again, the question is, how do you stop people from infringing it? But that's downstream to worry about, I suppose. So you can't, though, with a patent, unlike a patent, you can take it and you can wave it in someone's face and say, stop infringing this, whether they know about it or not. The trade secret, you can't do that. The trade secret, the only way to stop somebody from, I could independently develop your trade secret and use it. I'm not violating your trade secret because I didn't get it from you. I didn't hear from you or an employee. Yeah. But however, if one of your employees comes to my company and tells me about your trade secret, and I start using it, somehow it leaks back to you, I'm in trouble. And so is my employee. And there's personal liability there. It's not just for the company. And I think there's getting to be some criminal liability. So a trade secret can be very powerful in that sense. And I want to also tell you, trade secrets aren't just technical things. They can be anything that the company considers a secret. Could be customer lists, could be phone numbers, whatever you deem to be a trade secret. Maybe some object code in a software program, or who knows what. Right. So it's not necessarily something technical. People think about, so some things you just can't patent, and those are definitely trade secrets, like phone lists and little your route. And I mean, my law firm has trade secrets that we're not telling people about how we might meet two guys who have this really great podcast. That's a great secret.
Cool. Thank you.
All right. And another question is, what kind of things can be patented? Like, can I, for example, the first person ever thought about making a table or a chair. Can I patent something very, very general, not specific, like chair with 5 legs, with these kind of angles and this kind of tabletop, but very, very general. Like the idea of a table, for example. Can I patent an idea like that and basically block the world from manufacturing it for 18 or 19 years?
It would be 20 years from your earliest, what they call priority date. But that's how long it lasts. But let me just come back to your question. The law will only, the whole point of a patent is government or society rewarding you for making the effort to innovate something that's hopefully good for society. So you develop technology, a new chemical, a new drug, and they want to reward you by giving you this limited monopoly the last 20 years from your earliest priority date, not including your provisional or foreign filing date. But that's a little, just think 20 years from your earliest filing.
Okay.
There's more to it than that, but just for simplicity. So to do that, though, they'll only protect something that is novel and non-obvious. Let's touch on those two first together, each. the first thing is novel. You have to have created the world's first blank. So if you made this table and it's the world's first one that has a top with a bevel at this angle and a stick sticking up out of it, and it's novel, you've passed that test. And so you're good so far. But then the next part is, okay, you are novel. In other words, no one in the history of humankind has invented this. The world's first table that way. But I think it would be obvious in view of what other people have done in the past. And so wouldn't it be obvious? What's the benefit of making the bevel at this angle? Maybe you say, there's really nothing to it. I just chose to do that arbitrarily. Okay. Ideally, you have an answer something more to the effect, well, it's not obvious because I made this angle and realized that when this is used outside in the sun, it can reflect and it actually absorbs all the light and it makes the tabletop black. I'm obviously making this up. Yeah. But it has some sort of interesting effect that you sort of discovered that would not be obvious, would be unconventional. Mm-hmm. Then you might get your patent for that. Even though, and keep in mind, obviousness is very subjective. Mm-hmm. You might think it's obvious, Guy might think it's obvious, Nir might think it's not obvious. And so, and especially when you get this beautifully crafted patent application from a patent lawyer, and they hand it to you on a silver platter and say, here's my invention. Of course it's obvious. I mean, I remember in college, in physics class, learning about atom bombs and how they work. I was like, how come it took them so long to figure this out? Well, it's because my physics professor did a great job explaining it to us very easily. Yeah. But, it took thousands of people, millions of people. I don't know how many people. There's Manhattan Project, there was the German, everyone was going for it. Yeah. And it wasn't straightforward. So, and it's the same way with obviousness. In hindsight, everything seems obvious.
Right. Yes.
Every innovation that we have, also, you want to demonstrate there's a problem that you solve. So right now, I don't like standing. I don't like sitting on the floor. So somebody invented a chair. I'm sitting on a chair. And that's an innovation. There's a problem that's solved. So obviously, when the first person invented a chair, if there were governments that had patents, they could have gotten a patent on the chair. Mm-hmm. Anyway, so those are the two main criteria. There's been a lot of talk, though, recently about, and this is, I don't want to get too esoteric, but about before you even get to the point where you figure out whether something's novel or non-obvious, they don't want you to protect certain abstract principles, abstract concepts. They don't want you to protect mathematical equations and laws of nature. Mm-hmm. And they don't want to give protection if you make some sort of discovery like that. It's sort of like a business method. I know there's a lot of talk about business methods since '98 when a certain case called State Street Bank came out, but mm-hmm. there's been a push away from that. And I don't think that's a bad thing. People are trying to protect how to calculate the net asset value of a mutual fund or something.
Mm-hmm. Right.
That's stuff that they decided that they don't want to protect. And now again, I'm talking U.S., mm-hmm. but most countries outside of the U.S. will not protect those things either. In fact, many countries outside of the U.S. will not protect a method of treatment for a human, like a medical treatment. Mm-hmm. So I have some pushback on that sometimes in mm-hmm. certain countries also. So there are certain things that's like you got to get past that to get up to novelty and non-obviousness. And so one thing that's become a little clearer, and I say clear is a too liberal a term, but in the last year or so, they've really gone towards saying, well, you have to solve something technical with a technical solution. A technical problem, technical solution. And Europe is actually the same way. Europe has a requirement that they want to show what's called technical effect. Mm-hmm. And what does the meaning of all that? I mean, yeah, there's all kinds of things that you can say are technical, and there's meanings. It's a little less defined in the U.S. than Europe. I'm not sure exactly what it is in Europe. Mm-hmm. I mean, I think I know what it is, but that's why I have European lawyers to work with in Europe. They know it better than I do. In the U.S., for example, this tends to come up in software a lot. Mm-hmm. And I think we were talking before about the Alice versus CLS case that was the 2014 case that led to this issue of abstractness.
Mhm.
So most commonly it comes up in software. An example, though, of software where you're doing a technical problem and a technical solution is, say, you're developing software to transport packets across the network.
Right.
And so you're developing software, and it says, oh, you come to a node, and that node is broken. Redirect it in another way, and add a couple bits to the packet, and then strip those bits off. That's technical problem and technical solution. You're not going to have, you shouldn't, I should say, have a problem protecting something like that. That's very technical.
Right.
Let's go on the flip side. Say you invent a new statistic, or calculate, a new statistic that's used, say, in finance, or that's used in anything. And you're going to be able to protect that new statistic. You're going to have a really hard time protecting that statistic. And, or some mathematical technique. You have to show there's some technology or there's something else there, some subject, some substance or tangible thing to show it's not just this abstract thing that's in the air. Frankly, it's a mess.
So you're talking about usefulness, like if it's not useful, or?
Yeah, I'm talking about, but it's whether it's abstract or not, and or if it's a law of nature, or it's a natural, something that occurs in nature. That's and again, it comes up a lot in software and medical diagnostics. Those are the two areas where it's most prevalent. If you're developing a technology for a screwdriver that has a handle on it, you will not have that problem. And anything that, and in fact, most processes, if you're transforming, making something, you shouldn't have a problem. It just shows up mostly in software. Now, I have a slide I use a lot of times when I give talks, and the slide has just a few words. It says, "Software is not patentable," because it's not patentable. I hear people say, "Oh, software is not patentable," and I've been hearing that. I've been doing this 27 years. I've heard that since then, even. And software is absolutely patentable. The problem is it's something that the patent law was written in the U.S. in 1836. They didn't know what software was back then.
Right.
So they're having trouble molding it in. I mean, what if a software engineer develops something? Why is that less protectable than something a hardware engineer makes? I mean, they're using similar logic, similar issues that they're trying to get.
Right.
Now, this problem might be ameliorated or go away a bit because there's actually real progress going on in the U.S. Congress to amend the statute to make this very much clearer. I mean, it'll create additional ambiguities, but right now this is probably the hottest issue in patent law.
Really interesting.
Yeah.
So, but when you say the software is patentable, the algorithm that the software is doing is patentable, or the software itself is patentable? Like, can I patent?
I took it for granted. I know what you're saying, and I should have been clearer. The code is irrelevant. It's the algorithm. So anyone can code. I'm 27 years, I've almost never patented something having specifically to do with the code.
Okay.
It's basically you receive data, you chew it up, you add packets, you spend it out there, whatever. It's more like that. And so software is sort of a shorthand way of
the original way of doing something, basically, which is the algorithm.
It's a method.
The rest
it's a method.
Yeah,
it's a method or a process. And usually just a few steps. Of course, those few steps include the key differentiator, what's novel and non-obvious.
Right.
I've written some articles about this issue on 101. They call it 101 or Alice, or whether something's eligible for protection. And it's a real disaster out there.
Let's take, for example, what we develop. So just so we have something to discuss. So we develop an algorithm to extract vital signs of a human being or any other living creature like animals remotely using a radar, for example. And we do it in a certain way that is very, very efficient in terms of memory and computation. And let's say that I go ahead and patent this. And now basically what I'm doing is reveal to the world exactly what are the steps needed to do that so efficiently. now let's say that a major baby monitoring company is thinking about taking this and implementing this in their baby monitors. So first, how can I protect myself from that? Because I know I can take the patent and waive the patent and say stop doing it, or we will go to court. But what I'm more interested in is how will I figure out that they are doing exactly what I'm doing? How will I know to waive the patent in the first place?
So let's say you say you have the patent issued, let's say for your hypothetical situation. And so usually what happens is there's no patent police. You have to police it yourself. Okay. So the key is you're in the business, and so you know what your competitors are doing, and you have to find someone who's actually doing. You could buy their components and rip it apart. You can see what they're doing at trade shows. You can hear buzz around the industry. Eventually, it comes back to you. You get some sniffs that something's going on. You do your homework, and you say, "Hey, gee, there's someone infringing." Don't sue right away. You know why? Because they may not be selling much. They may be selling like very little product. They may not really be affecting your market. Maybe they have an inferior product. So you got to make a judgment, because a patent infringement lawsuit costs, I'm going to tell you something. It costs millions of dollars. I mean, $2 to $5 to $10 million you can spend to sue somebody for a full patent infringement suit.
Wow.
Many of them don't go all the way, so you might save some portion of that, but it's incredibly expensive. I heard someone once refer to it as nuclear war. It's like, but also, however, you got to think about, this is a business. This is not a personal thing. This is all business. It's about dollars and cents. We're just talking about money at the end of the day. And so you might want to reach out to them and say, hey, I have a patent here, and if you don't want them to do it, you can tell them to stop immediately using it. Or maybe you have the patent and you're okay, and maybe you work out some kind of deal with them where you get a royalty, and maybe you get a co-branding, or who knows what. Maybe they buy a certain amount from you. You can work out some sort of business arrangement. The risk with all that discussion is that they sue you. They do what's called a declaratory judgment action, where if they feel like there's an impending suit coming from you, which is somewhat of a high standard to meet, but nevertheless, they could sue you to say federal court, please declare that I don't infringe this patent. And it's basically the lawsuit. And then they start it in their jurisdiction, not yours. So that's dangerous. You got to obviously work with a patent lawyer, because there's a lot of hidden problems that people who aren't familiar with this process can really kill themselves, shoot themselves in the foot. For example, a lot of people say, I just want to send a letter out. Well, I like to say, if you're going to send a letter out, you better be ready to fight this battle. Okay? Just sending a letter out, if you just go away, you might lose your rights in the patent if you disappear. And they might, 5-6 years later, just use it. And you might never be able to enforce it, because they might get some sort of rights by their belief that you weren't going to sue them. So it's certainly, there's a lot of issues floating around. They may attack the patent in the patent office. There are ways to do that. So you have to
attack the eligibility of the patent, you mean?
Say the patent office screwed up and never should have issued this thing. And in that case, that could be very expensive. That's hundreds of thousands of dollars. And also, if that patent's very valuable to you and important to you, maybe you have another licensee. You have to consider, maybe you license this to somebody else. Of course, if you license to somebody else, you might have an obligation to enforce it if somebody's infringing it. And that's something to think about when you're licensing somebody. Do you want to agree to that? Maybe they pay for it. And you have to negotiate that. Another inherent question, though, that I think you might not have been asking, or you might have been asking, is how the heck do you pay for it if you're a small independent inventor or an entrepreneur who has very little money? That's hard. What I like to tell my startups in general is, you're never going to sue anybody in your patents. You're making this war chest, so in 3 to 5 years when you're acquired, they're going to sue, not you, and they got a lot of money. or if you're a public company for analysts, whatever, you're gonna have money. You're gonna be able to protect your market share.
Mm-hmm.
If you're just a little company, and there's no chance you're gonna be bought, or you're an independent inventor. I don't work with too many independent inventors, frankly. I usually work with companies basically exclusively. So the independent inventors, they kind of get ignored a lot.
Mm-hmm.
And so occasionally though, if you're in a tight spot, you can sometimes find attorneys who will, patent firms that will do it on a partial contingency basis. You can also find funders, actually people who invest in lawsuits, and they're out there, and you can certainly get them to invest in it. Of course, what happens then is though that you lose a little control of it, and you give up a lot of the reward at the end of the tunnel, whatever damages or royalties you get to them. So, but it's something sometimes you got to do it, and I know some lawyers that actually contact people who own pretty good patents and want to assert them. Now, the odds that somebody,
these what people call patent trolls.
that's one way of that is. One thing I want to tell you though is most of these law firms, before they take on one of these cases, they do a lot of analysis. The number I hear floated around is they'll spend $200,000 of their own billable time before they take a case on, and they feel like if they say no, that's $200,000 well spent, because you don't want to take on a bad case. So
right.
if they do take the case on, it's good. And they're getting approached a lot, the firms that are well known for doing this. There's a really great firm down in Texas that does it, called Sussman Godfrey, and they do it. There's some folks up here in Boston that do it, and like I said, even firms like Nutter, McLennan, and Fish. We work with people who fund litigation to help the small person protect their rights. Okay. But it's not an everyday thing.
Right.
It's a really good case, and don't forget, it has to be a good case not just for liability that there's infringement. It has to be a good case that there's a big infringement, like the infringement's 100 million, 200 million, 300. There's a lot of infringers. If there's like a company and the total damage is like $10 million.
Mm-hmm.
No one can take the case.
Yeah. At the end of the day, it's a business. Just like
all dollars and cents. Yeah. That's why I like being a patent lawyer better than other lawyers, because no one's freedom is at stake in my case. People's kids aren't being taken away.
Yeah.
It's just business.
Yeah.
And also technology. There's strategy. And another great thing about being a patent lawyer is most of my clients are really smart. In fact, I'd say almost all of them are, maybe all of them, because they're all innovative people and they're thinking outside of the box. They're really motivated and positive. It's a very upbeat career. If anyone out there wants to,
great.
It's really a lot. It's really an enjoyable. Like I said, I keep saying I've been doing this for 27 years. It went like that. I still feel like right out of law school in a way.
Yeah. That's great. By the way, something that I noticed lately is I see some patents with the exact same name but different patents. Can two different patents or more have the exact same title?
Yeah, it's what's important in a patent is what you claim as your invention at the end of the patent. Okay. And you claim it through something called claims, and they're kind of these awkward legalese type of things. And so sometimes you might see the same patent name, but the name actually doesn't have a lot of real effect on the scope of it.
Okay.
So most patent lawyers try to have a very generic name, because whatever, and it can hurt you, but it can't help you.
So the name doesn't have to be unique.
No.
Okay.
Like you could have something called device for fastening screws, and that the device could have some special titanium that's special, whatever. That's about. It could still have the generic name.
Okay. Okay.
The title's really irrelevant. The important thing, I think what you might have been getting at is if the claims at the end of the patent are the same, that's a big problem.
Yeah.
And so today, the way the law is, which I think changed only about 4 or 5 years ago, maybe, first one to get to the patent office wins. So if two patents have the same claims, the first one wins. But if somebody filed it before, like earlier than the date, I just can't recall the exact date, the first person who invented it wins.
Okay.
And trying to prove who invented it first is a very complicated process, which is one reason I think they changed the law.
Okay.
File. First one of the patent office wins. So what I'm inherently in that comment is that if you get to the you really don't want to waste too much time before you file your patent applications.
Yeah.
Got it.
And it's that way worldwide, pretty much. I mean, almost every country I can think of, first one of the patent office wins. So in that case, you file a provisional patent application if you're desperate to get on file quickly, and then you can kind of refine it and spin it out better.
Right.
Or you can just file a regular patent application quickly, just put the heat on your patent lawyer.
Yeah.
That's actually the next question. I think that most of our listeners are, as you said, innovative people, and most of them are startup type of people, and most of them are inventing or invented some stuff that they may wish to patent or not. But just for entertaining our listeners, what is the process or the common / recommended process of issuing a patent or a provisional patent, whatever you think is best in the beginning, and what is the average cost for that?
Getting there's really and there's a general process, but sometimes you deviate because they're different. Every person has their own specific issues.
Mm-hmm.
So like provisional, oftentimes what happens is you come to your patent lawyer and you sit down with them and you say, okay, I'm in this business. I am developing new technology. Help. What should I do? It's kind of like going to the doc saying, I don't feel good. Tell me, fix me. And let them ask a lot of. If you go there walking in saying, oh, I've been on 10 patents before, it still doesn't mean much because you've been through the process, like real basic stuff. But so you want to like have that patent lawyer ask you good questions. And the questions should originate business-focused questions. How are you going to make money on this? Well, I got this. If someone just comes to me and and they just want to talk technology, so they say, "Oh, I got a device that Gil and Nir should use. It shaves whiskers on your face, and there's a handle and a blade." And that's all we say. I walk away. I'm going to write a patent that's infringed with anyone who has something with a handle and a razor blade. Well, guess what? I forgot to ask. How are you going to make money on this baby? You're going to make money on the blades. You're going to give away the handle. So now that I asked the question about the business, how are you going to make money? I recognize I don't want to limit that patent to the handle. I want to forget that. I just want to focus on the razor blade. Mm-hmm. And so, so consequently, you and your patent lawyer he or she should be asking you questions about the business. How are you making money? What are your goals? Are you going to be raising money? You're going to license this? Do you want to get acquired? What's the supply chain? Da 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 da. And then let's talk about the technology. Now you're not going to ask every single one of those questions, but it's usually an hour and a half, and you'll discuss the technology. Of course, that's what you're going to talk about eventually the most, and mm-hmm. You're going to figure out how to fit the technology into the business case, like with a razor blade into your business, how you're going to make money.
Mm-hmm. Yeah.
Then you got to determine, well, what's the competition doing right now? How fast are they getting to market? What are they protecting? What's the state of the art right now? And you develop a filing strategy. Mm-hmm. It might mean just let's prepare a regular patent application, and you move ahead and you prepare a full patent application. Attorney's fees on that, depending on who you go with, anywhere from like $8,000 to $20,000. It just depends where you end up. Also depends on what's involved, technology. The life sciences one tend to be on the higher end, And in fact, they can be north of $20,000. The hardware, software, medical devices can be, usually in the lower middle to that. And then you file it. And that's usually half of the expense. That's like X, let's say. And you go through, you can accelerate that process, by the way, and get an examiner to review it right away. Right away meaning 3 to 6 months. And that costs an extra couple $1,000s for a small company.
Okay.
That's a good fee. And by the way, you're paying a government fee on top of all this stuff, but the government fee is like 10% of that,
Okay.
5. So, or you can just wait until the examiner picks it up from their queue. That could be 1 to 2 to 3 years. Yeah. They pick it up, they do a search, then they send you a note back saying you're rejected and here's why. And that's normal, very normal. And we get it back and it's one of 3 things. It's either they're dead on right, they're dead on wrong, or there's some wiggle room. So if they're dead on right, we have to modify what we're trying to protect to some extent. And there are rules on how you do that. If they're dead, or sometimes you just drop it. Like you might cut your losses and say, this wasn't worth anything. And by the way, hopefully you did a search before you filed this. And that could be also add another couple or few $1,000 to the front end also. But hopefully you did a search. That's actually, I left that out. That's really important to do, especially to make sure you're not obvious over something.
Yeah.
And that usually involves the law firm hiring an outside search firm. Law firms aren't terribly efficient at doing good searches. And I recognize that. And so let's focus on where we have our strengths, not that. Anyways, the patent examiner gets back to you. And so the first one is they're right. The second one is they're dead on wrong. And in that case, you just tell them, hey, you're wrong, and reasonably tell them a good reasoned explanation why they're wrong. Or the third one is, maybe they're right, maybe they're wrong. And you got to make a judgment call. Do you want to narrow it a little bit? Do you want to make it broader? Do you want to just fight it? And there's strategy going in that. So you prepare your legal arguments to go back to the examiner, and that's usually like anywhere from.
Usually, is it for the entire patent or just specific claims that the examiner is attacking?
He's usually attacking only claims. Sometimes he attacks the description, but usually it's claims you're fighting about.
Okay.
And so you would argue the claims, specific claims usually, and they get it, and sometimes they agree. I'd say more than half the times they disagree. So they may send it back and say, this is your final office action, which is not final. It's just, you can just pay a couple bucks and keep doing this process round and round, back and forth. So usually at this point, if you haven't spoken to the examiner on a call or in person, you do it because you want to understand what's going on in their brain, because a lot of times they don't have a lot of time and they might not write too clearly. So you analyze, you talk to them, and then it clicks. That is oftentimes the thing that makes it happen. So a lot of times we do it right up front. Sometimes we don't feel like we need to. So anyways, you'll do this process 1 to 3 times, and that 1 to 3 times, and then you get hopefully a notice of allowance, and you pay a fee, and it issues. The 1 to 3 times is usually another X. It's the other half of the cost. So it's so front end loaded. You're spending about half, and the second half you're spending about half. Now, if you can finish it in 1, of course, it's not going to be X. It's going to be a lot less.
Yeah.
And sometimes you get, like I had a case today where the examiner and I we talked and we got it allowed, and it was like $2,000 or something. I mean, it's not a lot to finish it up. So these responses can be anywhere from like $1,000 or $2,000 to 6 or 7 or 8, depending on how rigorously they attack you. They send you a 45-page rejection. It's going to cost a lot, maybe even outside of that range. They send you a typical 8 to 10-pager. It's going to be definitely in that range. So there's another piece, 2 pieces, other things to be complete is sometimes you don't want to go through that process. It's too early. The technology is not mature enough, or you're not clear in the market. Maybe you're raising money. You don't have the money. You can file what's called a provisional patent application I've alluded to earlier. And a provisional patent application is essentially a description of your invention. So that's written in a way that enables somebody of ordinary skill in this field to make and use the technology. That could be with help from your lawyer. Again, you sit down, you come up with a strategy. Now with startups, I like to have them do a lot of the writing, as you guys know, and I tell them what to write, and we have a strategy, and they send me a lot of written materials. It cuts down the amount of time I need to put into it. And that's like 2.5 to 3K usually, and you got a nice provisional patent application on file. I'd say 90% of the time, my inventors, who I mentioned are all smart, nice people, they actually do a pretty good write-up. They understand it. So then within 1 year of that date of the provisional, then you can start that regular process that I mentioned before.
But the provisional doesn't need to have claims, right? Or does it?
Correct. Does not.
Does not.
I like to put them in and call them innovations.
Okay.
And I like to interlace them together. That's something new I've done. Because in Europe, they're very strict. And if you have to demonstrate that combinations of all the different features can be put together in various permutations. And so I've learned my European lawyers that I work with very closely, a firm called Kaminsky Harman in Liechtenstein. They're great. And also I have two that are great, them and Hoffman Idle, which is another outstanding firm. But Kaminsky Harman is really great too. And they were like, yeah, you need to, they told me how to do that. So I do that in my provisionals. I don't do that in the non-provisionals. But if it's in the provisional, it carries over to the non-provisional anyway. So when I'm in Europe, I can always say, hey, look, they're all the claims are interlaced in the provisional. Yeah. So there's little tricks like that. So people say, oh, I can write a provisional. You don't know all this stuff. There's too much to know. These are just a couple things that I've explained to you. But there's so many little things that can go wrong. You say one thing, and it can just blow the whole process up.
Yeah.
So one thing I know I wanted, before you guys put another word in, you also need to think about non-U.S. protection. I told you all clients go outside of the U.S. So a year after you file your provisional, or a year after you file that first patent application, basically your first filing, whether it's provisional or regular non-provisional, you can file an international application. That's usually about $5,000. Most of that is government costs, $4,000 or $5,000, and that gives you another year and a half to decide on whether to file internationally in basically any country you want.
Yeah.
And then you go into all the different countries after 2.5 years total, and you spend a lot of money, $40,000, $50,000 to start, just to start. And then all those countries engage in the same process as I explained in the U.S., where the examiner examines it, it's back to you. Now, there are some countries that don't. Some countries just give it to you. But like South Africa, believe it or not, I file there a lot. I don't know why. People seem to like problem. They just register it and that's it. But most countries like Europe, European countries and Japan and China, they all give you a rigorous examination. So it's a big process.
Got it.
And so, and the foreign filing can really zap your budget. But you know the idea is you have 2.5 years to do that, and so hopefully you've raised some money, you budgeted it, and that's an important thing for your attorney to do. Your attorney should work with you as you get more sophisticated to help you foresee expenses coming down the next 12 months from now.
Right.
I do that budgeting exercise with many of my clients. And thankfully it's usually the end of the year. I'm sending out budgets all over the place and that because there's a lot of predictable expenses that FO won't recognize, and so we put together our proprietary trade secret spreadsheet.
Nice.
Budget. Yeah.
Cool.
Yeah.
So Steven, I think we're running out of time here, and I think I covered everything I wanted to cover. Did you hear?
Yeah, absolutely.
Why don't you tell the viewers where can they find you, how to contact you, if they have any patent related questions or they want to file for a patent?
Sure. A really easy way to do it. Don't forget, I do medical device, I do everything. But a real easy way to find me is go to Google and type in patent attorney and angel, and believe it or not, coming up on the top, right out of the top.
Let me try it right now. Let me try it.
Right now, see if it's happening. You're in California somewhere?
Patent attorney and
we're in Los Angeles.
Patent attorney and angel. Let's see. Yeah, you're here, man.
All right, so that works. That's been going on for the last several years. So Google seems to like me. Developed a nice reputation around this startup community through my. I'm an adjunct faculty at Boston University. I do a lot at MIT here in Boston, so a lot of mentoring and judging. So I get kind of developed a nice following here in Boston. But also they can Google me, just patent attorney Steven Saunders. That'll come up. Or Boston. If you really, you can go to my Nutter, McLennan, and Fish website and my information there, and enjoy with innovative startups, and hopefully, happy to chat.
And we will also for the YouTube posting, we will also put it down below the video.
Oh,
yeah,
great.
Put your email on the screen as well. Yeah.
Sounds good. Sounds good.
All right. Any other things or important things that I might have forgotten to ask that you wanna cover before we close?
I like to close. Unfortunately, it's not a joke. I wish I could. I'm not a comedian, but I like to close by saying, "Don't let the patent tail wag the dog." Okay. A lot of people, they do their whole business is based on optimizing tax strategies for their profits. Don't just try to get patents for the sake of patenting. Get something. It should be the natural result of your company's innovation and progress. It shouldn't be something that you're saying, I got to get patents. What can I patent? What can I protect? Or my patents are expiring. I need to get new patents. Because you need to, again, go back to the fundamentals. You've located a problem. Maybe no one's figured out the problem, or maybe others have solved it. And you have found a really good solution that has a lot of commercial value. That's when you want to.
All right. Great.
All right, guys.
Thank you for the wonderful advice, for the educational session. I hope this helps a lot of people that are going to be watching this. And talk to you soon. Thank you so much.
Thank you. Bye-bye.
Bye-bye.
Steven, thank you.